All right, folks. You ready to go in?
Yes, sir. You ready?
Yes, ma'am, please.
All right.
This is the Barron Circuit Court civil docket for the first day of February 2021. Normally, I first ask if anyone is in a big hurry, because I know there are a lot of these meetings going on around the globe, and you might have another one that you're late for. And a lot of times people have a lot of consternation if they have a federal court meeting or something. They're more worried about those federal court proceedings, and I don't blame them. So if you fit into that category, let me know. If you don't, I normally go chronologically, but my oldest case is the aforementioned Slavens versus TJ Sampson and others. And we have a pro se litigant in that case, and he's trying to get in. So I would need to skip it for a second until he had a better chance to get in. So anybody need to go out of order? All right. Thank you. Then our first case will be 20 CI 089 Ford and Ford and Keiko versus City of Glasgow and others. I believe this is, okay, he's in the waiting room. Let me click on. I believe that this is a motion to schedule a trial date. Is that right?
Yes, Your Honor. It's plaintiff's motion to schedule a trial date. The court entered a agreed order of scheduling. All discovery is to conclude on May 15th. So we believe that this case is ripe for a trial date. And counsel, everyone, correct me if I'm wrong, I think it'll take about a week to try.
That sounds about right. Judge, this is Jonathan Kurtz. I represent the third party defendant, Jonathan Shelton, that just got added to this case. The only thing that we'd ask is we've got an expert in the accompanying federal case. I don't know if you'd want some deadlines or what have you, but I feel like if I'm paying this guy to go and talk about this case in the federal case, might as well pay him to come to this case and talk about it as well. So if the council wants deadlines for me to disclose that expert, I guess now's the time to get them.
Sure. Yeah. Does anybody want to weigh in on that and let me know what they're thinking?
I think it's fine to set a deadline. That's fine. And depending on when the trial date is, Judge, we might want to revisit the May 15 discovery deadline.
Well, some of you have been unfortunate enough to have been trying to get trial dates for things that are going to take a week. And you may have already known where we are with that. I had multiple cases that were going to take a while, and this pandemic has jumped in and struck all of those off. So basically starting in the fall and working my way up to about March, I've got many, I don't know how many, multiple cases that are all between a week and 3 weeks long, supposedly at least. So my options that I can offer you are to either go out past all of that, or which is a lot of times when you're going to have experts, usually a better plan than the second option, which is to kind of double it on top of something else. But in the event that something else does not get settled or whatever the case may be, then you might have to get bumped. And I know that's really tough if you're paying experts to come testify live. I don't like to do that to anybody. Some cases everything's recorded or whatever, and so it's not that big of a deal. So I guess, Ms. Little, did you file this motion?
Your Honor, I'm here with co-counsel Mr. Whitfield, and we filed it on behalf of the plaintiffs, yes.
All right. So which one of those options would you rather? We'll go down the list, but everybody probably agrees.
Your Honor, could we do this? Could we set it as a backup and additionally set it for the March date so that if we can go, I mean, we're pretty ready to go and our experts are ready to go. And I think that their availability is, or at least our experts are pretty available. I've spoke with them and they can do it at the court's discretion right now. They're pretty open.
All right. I don't have a problem with that either.
John, do you have a preference?
No, I really don't. I think it's appropriate. We want to
as every plaintiff's lawyer wants to move it as quick as we can. And we fully understand, Your Honor, that with COVID, it's difficult. So a backup is okay, I think.
Okay. I'm looking at, I've got October, I have a slip and fall type of case. And then right after that, I've got a criminal case that the two of them kind of bridge a 2-week period of time. For those of you that aren't familiar with how, I don't ever really have a 5-day week to try anything because I've got another county that I've got to go to. So if any 5-day trial is a 2-week trial to me. I could do that. We kind of have to be banking on both of those cases settling, which, as all of you know, the slip and fall type of cases generally do settle. This other case is a criminal, like an embezzlement case. I don't have any idea. It's been pending for 3 years. The guy's had 3 lawyers, and who knows what's going to happen there. But if you all want me to do that, that'll get us a pretty quick date. And then our backup would probably be something along the lines of April.
Can we do that? Can we set it for the October and then go ahead and set it for April? And if we can go, we can go. If not,
Sure.
then we have the April date.
Yes, that's fine with me.
What dates in October, Your Honor?
Well, we'd be talking about the 13th through the 15th, which is a Wednesday through a Friday. And then the next week, whatever, I would have Tuesday through Friday the next week. So if we needed, all those days, you'd be talking 7 days. If we needed part of those days, we'd be talking, 5 or 6 days, just whatever you all. I'd probably just clear the whole month off. The whole week off, just because if we're going to do that, it wouldn't make much sense to put everybody in a bind. So if
That work? That work for everybody?
That
Yeah.
works,
Fine, Your Honor.
John?
everybody's okay with those
Fine
days,
with me. I'm fine.
we'll pencil that in. All right. Then looking at a backup. You got that written down? Okay. Looking at a backup here, I really, once I get to April of next year, I don't have anything scheduled. So if you wanted to look at something like how would you all, if we were going to take 5 days, would you prefer to do, what I think would be best would be to do 3 days. Like some weeks I only have 3 available days. So we could do 3 days, April 13th, 14th, and 15th, and then roll over to that next week and do, maybe the first 2 days or first 3 days of that next week, which would be, not counting Monday, which would be 19, 20, and 21, Tuesday, Wednesday, Thursday.
That's fine, Your Honor.
That
That'd
works.
be, yeah, that's fine.
I'm sorry that this is it's confusing, or complicated, but unfortunately.
Judge, it does look like the 15th is Good Friday that year.
Good point. That is usually a half day. I'm not sure why it didn't pop up on my calendar, but that's usually a half day for the state. So, that all that would mean to me really is that we could just play that by ear as we got there. And if we wanted to skip that altogether or come in for half a day, if there was a witness that we needed to knock out or whatever, and then I'll still have that next week. And I'll just leave all those days in that next week set for this case so that we have those to play with.
Fine.
Okay.
That works. Judge, do you have a scheduling order that you normally, or not a scheduling order, but a pretrial disclosure order you normally enter, or do you just want counsel to get together on that?
Well, I usually enter one that's got just kind of some broad strokes, and then if you all can nail it down tighter and want to, that's up to you. In this instance, I think the only thing you all have asked me to address is a disclosure of the potential expert that Mr. Shelton might have, which I assume Mr. Kurtz is ready to disclose that without too much fanfare. So
He will be, Judge, and I've got to get him some deposition transcripts, so it may take another 30 days or so, but other than that, yeah. we're
Okay.
ready.
Okay. So why don't we just put on there that can be disclosed by the, I don't know, we'll put the March, what is it? The 8th of March, which is a month and a week. Is that fair?
I think that'll work, Judge. I'm wrestling
Okay.
with my computer here trying to get that down. I haven't talked to him in a little while. If for some reason I call him and he's got other commitments and just can't get to read those depositions, I can file a motion or talk to counsel.
Okay, yeah, I mean, we've got enough time that I think you all could probably work it out.
Yeah.
And then, Mr. Cook, you were saying something about those other deadlines. Does this change anything, or should we leave those in place in your opinion?
Well, we had entered an agreed scheduling order a while back that made the final discovery deadline May the 15th. And since we're not going to try this case at the very earliest until October, it might make sense to bump that back a couple of months, for convenience for everybody.
Yeah, I don't object. I don't have a problem with that if you all want to.
Actually, Judge, that actually brings up an interesting point because we have a scheduling order in the federal case that we just extended. I don't have it in front of me. Matt, do you know when the plaintiff's expert disclosure in that case is?
I don't have it in front of me. I really don't.
My concern is I don't want to give Matt a peek into what the expert's opinions are going to be in the federal case by virtue of the state case, if that makes any kind of sense.
I'll be glad to do an agreed order in that one to alleviate that concern if you want to. It doesn't, I don't think that's a big deal.
Me, Judge. That's fine with you.
Yeah, I mean, if you all agree, at least in principle, to move those deadlines, then why don't I just let you all get together and come up with a time, and that way it intersects with the other case that you've got, and it, nobody's put over a barrel.
Makes sense. That's fine.
Case.
That works. Just,
Sure.
dispositive motions, do you have a deadline, or how do you want those heard?
Yeah, what we're going to need to, and that makes it tough with the 2 dates because I don't want to, I want to put a pretrial kind of way out in front of and by way out, I mean, maybe 6 weeks. That's not that far out, in front of that October date, so that we'll have a better idea of whether we're going to do it or not. My normal thing is to have motions filed prior to the pretrial, and then at the pretrial, we can discuss, we can either do a telephone conference or we can come to the pretrial, which would normally on a Monday unless we set it on a different day. We can discuss if we need a special hearing, because a lot of times these motions might take a few hours to get, if everybody's got them and you got multiple parties. So, what I will probably do here is set this pretrial for, let's look at August, the end of August is what I'm talking about. I got to find my calendar. Let's look at August the 30th. And motions be filed prior to that day, and then we can discuss any kind of, whether we're going to be able to, we think we're going to be able to have the trial, and if so, when we can squeeze in whatever hearings we're going to need to before, because that'll give us 6 or so weeks to get that done.
At 9 o'clock on the 30th?
Yes, sir.
Okay, good.
And so we'll just put in there that, dispositive motions filed prior to the pretrial motion. I may put a little, because I usually have a pretrial compliance that is usually 10 days before the pretrial. So I might put motions 10 days before just so that there'll be a consistent date.
Fine, thank you.
That works.
All
Thank
right,
you.
guys. Anything else on that case?
No, sir.
No, Your Honor.
No, sir.
Good,
Thank
Judge.
you all very much.
Thank you, Judge.
You.
All right, I believe we can rotate back to Mr. Slavens. I believe that's him.
Yes, sir.
Hello, Mr. Slavens.
Good morning, Your Honor.
We have, let's see, everybody that's interested in that case, just go ahead and state your name for the record so that we can make sure we have everybody.
Good morning, Your Honor. This is Bridget Coraz on behalf of Dr. Howerton and PA Stanley.
Okay?
Good morning, Your Honor. David Thompson on behalf of TJ Sampson.
Yes, sir.
Your Honor, David Straight on behalf of Dr. Davidson.
All right, very good. Thank you. Mr. Strite is appearing via phone, I believe. Anybody
I
else?
am, Your Honor.
All right. Mr. Slavens, I'm going to assume that you've seen these motions, but I am, just for the sake of making sure that you are fully aware of what's being asked here, I'm going to, who filed the, all your motions are essentially premised upon the same kind of argument, if you will. I can't remember who filed the first one. Ms. Corraz, was it you?
No, Your Honor, I believe Mr. Straight and Ms. Stratton filed the first one, and then mine was the second, I believe.
Okay. I suppose then, Mr. Strite, I'm going to have you state as succinctly as possible so that Mr. Slavens can hear. I'm going to ask you to state your motion and what you're asking me to do today.
That would be fine, Your Honor. You may recall that this was set for a status conference was set on this case last fall, and Your Honor entered an order which very specifically said that the plaintiff, Mr. Slavens, had to disclose their experts in compliance with Kentucky Rule of Civil Procedure 26.02 subsection 4 no later than the close of business on Monday, January the 25th, 2021. Of course, Your Honor, this is a medical malpractice case which requires competent expert testimony in order to sustain a cause of action against my client, Dr. Davidson, who is a physician, as well as all the co-defendants who are professionals or professional organizations, that a case like this cannot proceed unless there is compliance with that. One of the co-defendants filed a motion for a scheduling order last fall, which triggered Your Honor's order that was dated October the 22nd of 2020. That gave the plaintiff 90 days, essentially, to comply and come up with the necessary proof to sustain a professional malpractice case. Nothing was filed by the close of business pursuant to the court order. The following day, my client, Dr. Davidson, filed a motion for summary judgment based on the court's order. I think we could also add that, there is some other basis. I think that the court would be within its right to dismiss the case today for failure to prosecute, for failure to meet the court order. But at the very least, the 10 days for the summary judgment will roll on my motion this Friday. And I would ask, unless there is a competent disclosure filed, that the court put this case to bed as it pertains to my client. And I'm sure the co-defendants would have the similar things to say.
Okay. Ms. Corraz, you want to go next? And anything that you need to add, you can. If you just want to adopt most of that, you can.
I would, yes, Your Honor, I would adopt most of that. And then as we set out in our motion as well, currently, as I understand it, Mr. Slavens is attempting to represent, so the named plaintiff is Mr. Slavens individually and as administrator of the estate of his late wife. While he can certainly represent himself under Kentucky law individually for his consortium claim, Kentucky law does not allow him to pro se represent the estate of Nancy Slavens, and his consortium claim is based upon success of his of the estate's medical malpractice claim. So that was the only thing I would add to that argument.
All right, very good. Mr. Thompson.
I would adopt what the other two counsel have stated, and I don't have anything to add, Your Honor.
All right, very good. Mr. Slavens, did you hear all of that, sir?
Yes, I did, Your Honor, and I have read some information that was just supplied to me on Friday in reference to this matter. I had not received anything for that I had not attended or had been requested to attend. I did supply, according to the court order that I just received on Friday, that was signed by you. I had supplied the information to the attorney that requested it, Dr. Tappan, and he is also the world's expert on this type of injury or death matter. And I supplied it to all of the attorneys as well as the Loballo law firm did back in March of last year.
What specifically are you saying that you supplied them?
Dr. Tappan is the world-renowned doctor on this type of loss or death matter.
Well, but what specifically did you supply to these attorneys? I mean, just his name, or did you give them any other information?
I give them other information as well as their name, as well as his personal phone number. I supplied to them all information. All they had to do was read his report that they had received back in March of last year.
Do you have a copy of anything that you have supplied to any of these attorneys that are on here?
Yes, I do have a copy of the one from the Dr. Tappans out of California. And due to the virus going on, I was not able to bring copies over to give to you personally in court.
Understand. Does anybody know what Mr. Slavens is referencing? Because obviously, like he said, there's nothing in the record, which may or may not.
Your Honor, yeah, David Strite for Dr. Davidson. I can tell you that, to best of my knowledge, when Mr. Slavens was represented, we were never provided any preliminary disclosure or certainly formal disclosure of Dr. Tappan. And since Mr. Slavens has been proceeding pro se, I have not received any information as it pertains to Dr. Tappan. This is the first I've ever heard of his name.
Okay. Anybody else have any knowledge of that?
Your Honor, I have no knowledge of that. As we noted in our motion for summary judgment, our office did receive that purported expert witness disclosure from Mr. Slavens that I believe was not filed with the court. While we did receive the list of physicians, including Dr. Tapson's name on there, to my knowledge, we do not have any expert report from him. And like Mr. Strite said, prior to Mr. Slavens representing himself, to my knowledge, we never received that.
So when did if you did get something, when was it? Do you have any way to track that down?
That was, I believe it was last October that we received that via mail to our office. As set out in our motion, we sent Mr. Slavens a letter explaining that was not filed with the court and that was not in compliance with the civil rule. But we did receive that list of physicians in October of 2020.
Was it before or after you filed your motion to put a scheduling order in place, which I think was filed October 12th?
You know, I can't recall if it was around the same time. And so I don't know if they crossed in the mail. I don't know exactly.
Okay. All right. Fair enough.
Your Honor, can I jump in here a little bit?
Please do.
I'm just kind of looking at all the materials. So I think what happened is co-defendant put on their motion for a scheduling order because the case had kind of sat dormant for a period of time after plaintiff's counsel had withdrawn and Mr. Slavens was proceeding pro se. Then it looks like he sent something to Mr. Gazak's office and Ms. Koraz's office on October the 9th, according to their filing with this court on the motion for summary judgment. This list of doctors that he provided to them was not sent to anybody else. It doesn't sound like Mr. Strite got it. I know my office didn't get it. And it looks like there was an exchange of correspondence between Ms. Koraz and Mr. Slavens thereafter. The first time that I saw any of these names, and I'm going to come back to the names very briefly in a second. The first time I saw any of these names was in looking at the motion for summary judgment that was filed last week. And so Dr. Tapson appears to be the only retained expert. He has listed several other names, local doctors, Dr. High in Tompkinsville, Dr. Loy in Burkesville, and a Dr. Ibakwe in Bowling Green. I think those are all treaters. I don't think those are retained experts just from looking at them. Dr. Tapson does appear to be a retained expert from Los Angeles, but all we have is a name. And when I say all we have is a name, that was seen by me and apparently by Mr. Strike for the first time last week. There is no disclosure. And I went back just as we're having this discussion, there was no production of a report and no production of anything by plaintiff's counsel as part of the discovery process. So we, Mr. Slavens may have gotten some incorrect information from his prior counsel, but none of us, as we sit here today, have any information whatsoever about what Dr. Tapson may be prepared to testify regarding. And I will just add that my client is involved in this, and I think everybody's involved in this because of one emergency department visit to TJ Sampson. And from looking at Dr. Tapson's bio, he does not even appear to be an emergency medicine doctor. So I think we've got a number of potential problems with this potential disclosure that we're dealing with. But ultimately, as Ms. Koraz said, Mr. Slavens can't represent the estate anyway. And so even if this is deemed some type of effort at compliance, he can only do so on behalf of himself individually. And there would need to be not only counsel involved on behalf of the estate, but they need to get an expert disclosure filed, I think pretty quickly, as Mr. Stride indicated in his argument.
Yeah, as much as that sounds like I guess a technicality to a non-attorney, the insurmountable problem is that a person can only represent himself unless he or she is a licensed practicing attorney, in which case he or she can represent other people besides himself. And in this instance, Mr. Slavens is himself. He is also the administrator of the estate, but he's not the estate, so he can't represent the estate because he's not a lawyer. That is a much more convoluted way of putting it than you all put it, but I was attempting to try to say it in a way that he would understand what you all are talking about, which is that the estate is not a natural person. It's for lack of a better way to put it, a legal entity that has to be represented by an attorney if it is advocating for its rights in some. He can do estate things in an estate case without an attorney, but he can't represent the estate in cases that are not the probate case unless he is an attorney. And I think that's what all of you all are saying, and I think I agree with you. So that is really all of you all know the rules about, you can't use a summary judgment as a lever to or as a way to punish somebody for not complying with the discovery rule and all that, and everybody understands that. But what really where we are is that unless there is an attorney representing the estate, then whether it's now or later, that it's necessarily going to fail. I mean, I guess you could go all the way up to the trial, and if there isn't an attorney, it would have to be dismissed at that point. As Ms. Koraz put out, the success, if any, of any claim that's derivative of the estate claim would also depend on the success of the estate claim. So if it fails, any other claim that's derivative of that would fail, which would include his personal his consortium, I guess is the way that it's been characterized. So all of that sounds like a bunch of mumbo jumbo, I would think, to somebody that's not an attorney, but it isn't mumbo jumbo to the rest of us. And that's the biggest problem that I see. Not obviously the other issues are problems. if there's a disclosure deadline that is not met, those are not in there just to make it, traps for the unwary. I mean, those are in there because people have to know what's going on and what experts are going to say if you're going to have one, and what they have done, what they've looked into, what they plan on testifying about, and all of that. Not just, this is a guy out in Los Angeles that we've talked to, and here's his number if you want to chat him up, because that's not what is required. So I guess where I'm struggling is to try to figure out, if the estate is not going to be represented, then all the rest of this is an academic exercise in all reality, whether it's brought to fruition now or later. And I want to be fair as I can possibly be to everybody, but that certainly includes Mr. Slavens. When his attorneys withdrew from his representation, or from their representation, whenever that was, back in the spring or summer of last year, right?
March. It was March, Your Honor.
March, right? Okay. So it's been almost a year. And when that happened, they tendered an order. I was not really thinking a year down the road, and maybe that's what I should have been doing, but I did not amend that order or add anything to it that said he's going to have somebody employed to represent the estate, or it can't go forward. And therefore, he hadn't really been put on notice of that unless his prior counsel informed him of that, which I don't have any way to know if they did. So where I am right now is trying to make sure that he has the fairest opportunity that he can have, while not dragging this out interminably either, which is what the defendants are entitled to, is to not just have this thing languishing forever. So my thought on it is this. I believe that I probably should put some sort of a time limit on the ability of Mr. Slavens, if he can, to employ counsel to represent this estate. It's not a question of whether you would want to, it's a question of whether, if you want any chance for your case to proceed, you're going to have to. And that's just a rule about representation and about parties being represented. As Ms. Corraz put out, he's free to represent himself if he wants to, just like anybody else is, but the estate is not himself. And I feel like I would need to do that because that's gonna answer the question if that doesn't happen. That's gonna make all the rest of these arguments moot ultimately if the estate is not represented, because it can't proceed with litigation if it's not. Does anybody disagree with that? I mean, I could be wrong. There may be something I'm not thinking of, but you won't hurt my feelings.
Your Honor, in terms of securing additional time, or a period of time certain to represent the estate, I think that's one thing, but he has decided to represent himself on the individual consortium claim. And I would point to the fact that your order from October specifically told Mr. Slavens that a generalized statement outlining the broad subject of which the expert may testify does not sufficiently comply with the rule. And that under this order that he had to disclose the details of the report. And so I think that that Mr. Slavens decided to represent himself. And as to his individual claims, I think that's at least fair games for dismissal today, or after the 10 days on this dispositive motion. I mean, your order of October was pretty clear on this point. I neglected to remind you of the footnote to the order earlier in my statement. So that would be my only comment to that.
Yeah, and honestly, when I entered that order, I was attempting to avoid anything like this, but it did not occur to me that the estate, the pro se angle as it pertains to the estate, that did not occur to me to put him on notice of that. And I just feel like, as a matter of fact, and I'm not saying that the outcome is automatic if he does get an attorney to represent the estate, because I still think your all's points are both legitimate and ripe to be advanced. I mean, you could still make the argument, hey, listen, regardless of how long it took to get an attorney or anything like that, this deadline has come and it's gone, and there's been no disclosure consistent with it. And, this is only to kind of give him, as a pro se litigant, every chance in the world to live to make that argument. I'm not saying that I'm not going to agree with you ultimately when we get to that point. I feel like this is something that needs to happen before we get to that point. Your point about the pro se aspect of the case and the lack of disclosure and the rightness for summary judgment, all of those, I'm not deciding against you on that. All of those are fair game, for lack of a better phrase, to be argued. I don't, I agree with you on that. And I'm not saying that those are points. All right.
Okay.
Yeah. And it may be that as it progresses, and if there is an attorney comes into the mix, that I can grant a partial summary judgment as to one claim and not another claim. I mean, that kind of thing's been known to happen. I would leave that open. But Mr. Slavens, I don't know how much, I hope you've been following all of this. I'm trying as much as I can not to use over technical terms here, but what I believe the situation is, as it stands right now, is that unless you get an attorney in your capacity as the administrator of this estate, unless you employ an attorney to represent the estate, there's no way that this case against the hospital and these doctors can proceed past this point. Even if you do, they might all be right and it might get dismissed. But if you don't, it'll have to get dismissed because you can't represent the estate unless you are, and I'm not saying this to be a smart aleck, unless you are an attorney and I'm not aware of it. Okay.
I understand. And Your Honor, let me clear that one point up for you. I am not an attorney, and I understand, and I appreciate what you're suggesting here. And there's only one thing I would request in addition to this is that instead of receiving these documents the day, or should I say the weekend before the court hearing, that I receive these in a timely manner, which I have not. These attorneys have not supplied the information, as you just made mention, Your Honor, that I was not aware until now that I needed to have an attorney to represent the estate, or I would have went out and mortgaged my home or whatever it took to get an attorney to represent me.
Understand. All right. Well, and again, that's another one of these perils, I suppose, of being trying to handle things yourself, is that a lot of times you don't have a regimented way for your mail to come in like these guys do that have post office boxes and different things like that, but anyway, that's not going to matter right now. I mean, going forward, we need to make sure that we notice or send everything to you unless there's an attorney that gets into the mix. Now, the next question is going to be, how long do I give you? Because reasonable minds are going to take a different approach to this. These guys are going to say, well, you've had a year to get an attorney because your other attorneys got out almost exactly a year ago and 11 months ago, whatever the case may be. And so they're thinking that I don't need to give you a whole lot more time, I'm sure. On the other hand, I'm thinking that I don't need to say I'm going to give you time to get an attorney and then give you 3 days, because that would be futile and unfair. So, but normally what happens in a situation like this is that if you're going to give somebody time to get an attorney in a case that's been lingering around for a while like this one, you give them 30 days or something like that. So, I'm inclined to look at a date somewhere in that ballpark, Mr. Slavens, to, so that this thing can start moving. Okay.
I don't have a problem with that. The only thing that I have a thought on, Your Honor, is this, and I appreciate you being fairness to me as a dumb person on the side of the road, not an attorney. But is that a lot of the offices, including attorneys' offices, are not accepting clients and they're not accepting walk-in people at this time due to this virus. So I don't know what I'm going to encounter along those lines. And to find a competent attorney that can represent me in this matter. Most of them are the high price guys that's already sitting there talking to you now.
Well, it would never, and I'm going to be frank with you, it would never be easy to find somebody to represent you, after the case has kind of been dealt with by a couple of different attorneys, which is what's happened in your case. And, I do appreciate that it might be a little bit more difficult than normal. 30 days might be unrealistic just because it might be harder to get in to see somebody. But I will say this, I believe that now that we're almost a year into this pandemic, most of the attorneys are also pretty adept at video conferencing with people and doing things like that like you're doing right now.
Yes, sir.
You may have to call an attorney, but a lot of these guys, they aren't really going into their office all the time, but they can do it from home, or their paralegals can work from home, and Zoom pretty much will work anywhere. So, I think you'll be able to, I don't believe that you'll be hamstrung a whole lot by the current circumstances, although it might be fair to build in an extra few weeks on that just to account for that.
All right, Your Honor, and one footnote for you, if you don't mind, sir, is that I will do my most best to find an attorney, and if I'm most successful, I will address this issue directly with you to let you know. I'm not going to leave you hanging.
Understand. Well, what I'm going to do, and I'm probably, I'm going to do a little bit of counting, but I'll probably put it out about 45 days and just give you a deadline by which to have an attorney enter an appearance, file a formal entry of appearance. And because I don't know what'll happen, we will just wait and see how that plays out. And then if any of these, if there is not anything, then I'm going to take these three motions under consideration and rule on them. If there is something, then, we'll have to see how that plays out if there is a entry of appearance filed. But I am going to, in the order that I do, point out that there is a deadline that has come and gone already with respect to expert witness disclosures, because, an attorney is going to need to know that to decide how to handle things. Okay?
Yes, sir. And I appreciate your time, Your Honor, this morning. And again, requesting again that all of the attorneys that's involved on the other side of this matter present the information to me in a timely manner instead of the day before or the weekend before, so they can address these issues properly, as well as any attorney, if I'm able to find one.
Your Honor, just on that note, we emailed our filing to the email address we had for Mr. Slavin. So if he could just restate his email address to make sure we're, at least my office, and I presume the others are working off the correct email address.
I don't have a problem with that, Your Honor.
Yeah, go. I assume it's the same one I used, because that's how you got notice that we were Zooming here.
Same one.
When I got these motions, I emailed it to you.
Yes.
Could
sir.
you just
I
put that on the
appreciate
record, Mr. Slavin?
it. Beg your pardon?
Yeah,
Mr.
Mr.
Slavin,
State it on the record.
would you
State your email address.
Okay, it's all lowercase. It's V, like my first name, slavins@hotmail.com.
That's not too complicated.
No, I hope not.
Nope, that's one
Yeah.
of the good old fashioned ones.
That's me. I'm
That's
old
what-
fashioned, Your Honor. I'm
That's
what we have
on the
old,
record,
I'm
Your Honor.
old-fashioned.
Yeah, it's easy to remember. Okay. So I'll get an order out for you all today, or well, it'll be tomorrow. Okay.
All right,
So,
thank
Your Honor,
you.
just so I understand, is your order going to be 45 days just to secure counsel, or is there going to be some requirement for expert disclosures to be made then, or are you going to kind of just reference the expert deadline having passed, and then we'll deal with that if counsel gets involved?
I'm going to reference that order from October, I believe it was, and
Yes, sir.
the deadline that was in the order, and that it, I'm gonna just reference that for full awareness of anybody that looks at it.
Okay, I appreciate it.
Okay?
Your Honor, if the 45 days passes, do you want us to file a AOC or something with the court, or will you have your own tickler system, or do you want defense counsel to do something?
I am not going to tell you not to. We will try to put it on a calendar to trigger it, but
Okay.
I mean, anytime that you got the human element involved, I guess the more humans that are trying to remember something, the better off we all are.
Okay. That'd be fine,
Okay.
Your Honor.
All right. All right. If there's nothing further in this case, then I'm going to move on to these other folks. Okay?
All right,
Thank
thanks,
you, Your Honor,
everybody.
and I appreciate your time.
Thank you. Thank you, Your Honor.
All right, everybody. Sorry about that. My next one is 20 CI 143, Bank of New York Mellon Trust versus unknown spouse. This is a motion for, well,
Your Honor, Philip George on behalf of the plaintiff.
Yeah.
It's our motion to compel the warning order attorney to get the motions filed. We had some communication with her back and forth, but delays happened. But I was able to speak with her. She indicated to me this morning that she got the warning order report filed on Friday. I haven't seen a copy yet, but assuming that was filed, I'll go ahead and withdraw my motion.
it was filed and it was Friday.
All right, thank you, sir.
I haven't read it either, but it's in there.
All right, well, I'll withdraw my motion then, Your Honor.
All right. Thank you.
Uh-huh.
I'll just write a calendar note on that. All right, everybody. 20 CI 296, Barry versus Edwards, Davenport, and Averett, and then a bunch of other folks. All right. It'd take me too long to read all that.
Yes, Judge.
All right. Let's see. We have ourselves a motion to compel.
Yes, Judge. This is Shay Conley. I'm here for Jackie Berry. Mr. McGill represents Mr. Edwards. The only thing worse than a pro se litigant discussing expert disclosures is probably going line by line through 20 discovery responses that have been briefed thoroughly to the judge. We can do that, but I would defer to your preference, sir, on how you want to handle it.
Sure. Well, not that I don't trust all of you, but even if you went through it all, I'd have to read it all myself anyway. So I generally like to just go by what's in the record if Now, that being said, if there's something in particular that anybody feels like bears special attention or highlighting or whatever the case may be, I'm happy to listen to you. But I haven't gone through this one, so I don't really know exactly what the main issues are, and I'd probably benefit most just to read it all when I get the chance and tell you what I think.
That's fine with me, Judge. And in fact, if after reading it you'd request a hearing, just shoot us a notice and we'll clarify anything that needs to be done
Sure.
for the hearing.
Anybody have an issue with that approach?
Judge, the only issue I have with it, and this is Gene Zipperly on behalf of Averett and its driver, Mr. Davenport, is that, we're painting a very broad brush here with respect to the plaintiff's discovery responses. And in particular, we're getting a lot of requests nowadays for production of documents with respect to what's called the accident register in this case. And so the accident register is a federal document that all trucking companies are required to post with the federal government that kind of lists out since that the motor carrier has had for several years. And it doesn't just include the accident involved here. It includes every accident, no matter where it's occurred and what state it's occurred and what the circumstances are. And under the regulation, Judge, the only things that are required to be posted in the accident register are the name of the driver, the date of the accident, the location of the accident, whether there were any injuries involved, and whether it involved hazmat. That's it. So we are very reluctant to have this court order us to turn over an accident register that contains data about accidents that have absolutely nothing to do with this case. And the problem I have with a lot of what the plaintiffs are doing here is essentially with the accident register in particular is they're trying to switch the causation element of cases like this, as people often do, from the actual accident itself, when you had Mr. Berry who crossed a double yellow line to try and pass a line of slow moving traffic about the same time as the Averitt vehicle did the same thing. So it's kind of like no harm, no foul for both of them, to focusing on, maybe dozens, maybe hundreds of cases over the years, ranging from property damage to whatever, that have absolutely nothing to do with this case whatsoever. So, in particular, we would request that the court not order us to produce the accident register, or that the court, if it's inclined to say that the information is relevant, that the court just order us to produce what information is in that particular document that pertains to this accident in and of itself.
Okay,
That's all briefed.
say again.
That's all brief. That's all brief.
Yeah.
So
Okay,
if you-
yeah.
And Judge,
you
we'll
wanna
also
attack
reserve
it,
our
that's
right to request a hearing on this, depending on what the court determines.
Yeah, okay. You address that argument in your motion, and I'm sure that's also forwarded in the response. That argument is put forth in the response. So I'll just look at all of that, and if I feel like I need anything additional from you guys, I'll get with you.
Thank you, Your Honor. Appreciate your time.
Thank you.
Thank you, Judge.
Malden, you're here for that case too?
Yes, sir. Mr. McGill represents me today.
I was wondering how we got, I didn't want you to go sit here for an hour and not get to say anything.
I appreciate that. I was officially here since I spoke to you.
All right, good deal. Yeah, I can vouch. All right, thank you.
Thank you, Judge.
you.
Thank you.